Hey, Lisa, hot off the presses, California age-appropriate design code and Ninth Circuit just ruled on that. Can you tell us a bit about it?
Yes, hot off the presses is right. This is a big deal. It's a big deal for Age Appropriate Design Code Act implications, but also just privacy laws. So the appellate court focused on one issue, and it was the data protection impact assessments, essentially saying strict scrutiny under First Amendment, which for the legal nerds, that's the highest standard, because they said the law, essentially what California did is deputized businesses to censor speech, that they were compelled, forced by the government to create DPIAs. And even though they were not going to be published on websites, that they were forced to write down certain speech to address what the state thought were potential harms, that was ambiguous, and that they could not do that under the First Amendment. So that provision, the DPIA provision of the Age Appropriate Design Code Act, struck down, and then the rest of the case sent back down to the district court to essentially do over, reassess.
What does that mean for privacy laws? Does it mean anything?
Well, I think it does, because if DPIAs, data protection impact assessments, risk assessments, by companies internally assessing what are the benefits, what are the potential harms. We have this issue in what are harms in the privacy context that are enough. And if DPIAs potentially violate the First Amendment, now here this was about children's privacy, but in the privacy laws, we're talking about sensitive personal information. We're talking about just personal information, not sensitive to different groups of individuals. I think it's a good question on whether you're going to have advocacy groups like Net Choice or others look to challenge laws, for example, like the CCPA on some of these provisions, or Maryland's law that has pretty restrictive language around sensitive personal information, or even some of the AI laws that we are seeing, like in Colorado. So I think it really raises the question of where do we net out, not to use the word net with Net Choice, but where will we net out for after some of these statutes, in fact, are challenged?
Yeah, so like so for example, I was under the assumption that just the violation of your privacy is the harm. And does this mean that's not necessarily the case? And that even asking businesses to think about the harm, it's not their job? I mean,
Well,
thinking about that right?
to think about the amorphous harm, the concept of what is harm. And we've seen in the data breach cases, for example, when those were litigated, they were really looking at economic harm, concrete harm to individuals. And while we certainly hear regulators talk about harms to be a much broader, more elastic concept, I think what you're seeing is courts push, we need to be more specific when we are saying something may harm. And if you are going to not do certain things or force disclosures to do certain things, those harms need to be more particular. Businesses need to have more specificity and essentially a higher burden on what the state or the federal government, depending on the law that's challenged, has to be more articulate about the harms that they're trying to protect.
And do you think, Alysa, that, I mean, some aspects of the privacy laws are ambiguous anyway and might need more specificity? So, for example, the FTC blog on browsing data being personal, should that be encoded in law, especially after Chevron? Are we just going to see more of this?
Yes, we are going to see more court-based challenges on where to draw the line. And yes, government has an interest in protecting privacy, but what is a reasonable place, and how specific does the government need to be? I think there's some big questions on whether blog posts are going to carry the day.
Thanks, Alysa.